Good day, Crime Talk aficionados. We have a great show as we head into the weekend. First, a few more thoughts on that Bryan Kohberger matter we discussed yesterday. A scandal is brewing in a Colorado school district. Prosecution. Yeah, they want the Sydney Powell's convictions reinstated after it got reversed. A story of two very sick men. An example of why a protection order is only as good as the piece of paper it's written on. We have This Day in Legal History and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And you can check us out on any of your favorite podcasting apps. Now, please go to crimetalksearch.com and sign up for that background subscription service today. When you do, you're going to be able to do a background search on as many people in the United States that you desire. So whether it's somebody coming into your life, or maybe you're just a sleuth on your own and you'd like to check out some of these witnesses that are in these cases, guess what? You can do those background searches on them as well. So go to crimetalksearch.com. You're going to get that background search literally emailed to you moments after it's been prepared, and it's going to have all the information you are looking for. Their social media presence. Are they employed? Do they own assets? Do they have judgments against them? Are they married? Are they divorced? Do they have a criminal history? And yes, do they have to register on one of those public registries you hear so much about? Go to crimetalksearch.com. Check it out. You're going to be happy you did. Listen, information is power. It could even save your life. All right, let's go ahead and open the record for Friday, February 14th, Valentine's Day. That's right. Happy Valentine's. May all of your wishes come true on this Valentine's Day. All right, so let's go ahead and get to the docket today for Friday, February 14th. First on the docket, I wanted to talk a little bit more about the Bryan Kohberger matter that we talked about yesterday. And there were a lot of comments yesterday. There were lots of views on yesterday's show. And we've really focused the issue that it comes down to. The exchange between Bryan Kohberger's attorney and the judge about the ultimate issue in this case. The judge nailed it. And it's what I've been saying all along is, why is your client's DNA on this knife sheath in the house underneath a body? And everybody knows that's what the case is all about. The fact that there may be some partial samples that they were not able to develop, they being the government were not able to develop when they sent those off to the crime lab. So what that means is simply, it doesn't necessarily mean that there were other people there, because you don't know when the blood of these two unidentified sources of blood came from. All right. And all that means is that it is a partial sample. And that means that there wasn't a sufficient enough sample to make enough of an identification for it to even be uploaded into the CODIS system. Now, we may not know, if ever, where those two other samples came from. I think it's somewhat unlikely that Bryan Kohberger, this guy who had trouble making friends, not very sociable kind of guy, somehow conspired with two other people to go to this residence and kill the people in the home. Now, obviously, we will give Bryan Kohberger the presumption of innocence, but like I said, why is his DNA on there? That is the million-dollar question, and that is what even the defense attorneys brought out and agreed with the judge during that colloquy between the judge and the counsel. The other thing I just wanted to highlight is that just because the prosecution doesn't put everything in an affidavit doesn't mean that you automatically get a Franks hearing. And I don't think the judge in the Kohberger matter is going to grant a Franks hearing, because you have to look at probable cause as it relates to the individual defendant. And in this particular case, it was Bryan Kohberger. And his DNA being on that knife sheath button was enough for the court to establish probable cause for Bryan Kohberger. It's not like if they didn't put in there, oh my gosh, and we found two unidentified blood samples of two unknown males and some blood on a glove outside the residence. that, oh my gosh, Bryan Kohberger needs to go free. No, that just means that maybe somebody was there at a party and cut their hand. Maybe the guy dropping off the food. There's a bazillion possibilities that could come up with as to why the blood was there. This was a very active house, etc. So the fact that that information was not revealed in the affidavit for the arrest warrant, as well as probable cause determinations for other search warrants, is not enough to kill the case for the prosecution. And don't get me wrong, it would be a much better trial to watch. I mean, it's going to be interesting, but it would really be good if the prosecution didn't have some of this evidence, i.e. the case would go away. So I don't think any judge is going to do that in this particular case. I don't think there was some great conspiracy to frame Bryan Kohberger at that particular point. I haven't seen anything, but hey, maybe the defense has something that we don't know about. We're going to have to wait and see. But I think people need to just, hey, we got a trial date coming up. Let's wait and see what the evidence comes out to be. And, you know, I had lots of people comment and send me stuff that, you remember that whole Amazon purchase that possibly the one that they once suppressed may have been the purchase of a K-bar? Bad fact if that turns out to be true. So anyway, like I said, the prosecutors did not dispute those claims, meaning that the evidence is likely to feature obviously quite prominently at the Kohberger trial, but we'll have to wait and see. And like I said, the Judge Hippler pushed back on the defense, citing the leather knife sheath found in the bed of one of the 4 victims with DNA that matched Kohberger. And the judge, and we're trying to find you this clip from the video, which says, how does that, even if disclosed, preclude a finding of probable cause? Because there's a DNA match between the DNA on the sheath and Mr. Kohberger. The judge nailed it. And isn't that probable cause every day and twice on Sunday? The judge said, because he knows it is, and she knows it is. However, Ms. Taylor, Bryan Kohberger's attorney, argued that probable cause shouldn't be considered in a vacuum. And if that's the only thing that she was told, I can see why she'd find probable cause, the Ms. Taylor told the judge. But if it's these things and other things that are withheld that create a context around it, do we want to have one with no context around it when this other context really matters? Well, that's what trials are for. That's what motions practice are for. You know, we saw in the Suzanne Morphew case, the affidavit for the arrest warrant was 122 pages long. A lot of it was speculation that the judge said I couldn't even consider because it was so much speculation. A good arrest warrant in a murder case, usually a couple of pages at best. You don't have to put, throw the whole kitchen sink into the affidavit, but you have to put what is necessary to establish probable cause. If there were 5 other people there, it doesn't matter that it wouldn't establish probable cause as to Bryan Kohberger. So just remember that when you're hearing other people saying this case should absolutely be dismissed. No, that's not the way our legal system works, whether it's a civil case or a criminal case. The original allegations are basically deemed as true for the case to go forward. Ultimately, if the case resolves, there won't be a trial, but if not, we have a jury trial for 12 jurors to hold the government to their burden of proof beyond a reasonable doubt and to decide whether the government has proven their case beyond a reasonable doubt. And if not, then the solemn oath and obligation of those jurors would be to say not guilty in the case of Bryan Kohberger. However, if the jury felt that the prosecution had met their burden, then it would be their solemn oath and obligation to say guilty. And then they would go on to the next penalty phase. So I can't wait for that to get here as quickly as possible. Trial should have been happening a year and a half ago, but we wait. Like I said, that trial is scheduled to begin in August. Next, a little controversy brewing in a Jefferson County school district here in Colorado. The school district is apologizing to the parents of a Columbine High School student after school officials helped the student lie on a federal form and then hid it from her parents so that the child could move in with the teacher. Yes, that's right. So investigators hired by the district, the student, who was 17 years old at the time and female, was involved in an inappropriate relationship with a social studies teacher by the name of Leanne Kearney. Friends with the young girl's mother said that there were red flags long before the district hired investigators. There's this icky feeling that something is wrong, and it's progressed and it's only gotten worse. Not a single person stood up and said something doesn't seem right and reached out to the parents, not one. Instead, school emails obtained through open records requests for this investigation show that counselors purposefully kept the parents in the dark while they helped their daughter declare herself homeless so that she could go move in with the teacher. That's a little scary, ladies and gentlemen, right? Your kid is getting form signed through a teacher saying that you're homeless so that you could go move in with that teacher. Now, this 17-year-old girl, the student, moved in with the female teacher. Could you imagine if your 17-year-old daughter moved in with a male teacher? Don't you think there would be a few more red flags about that? Why weren't there red flags at all? Crazy. Anyway, the school district, now that they have been caught, so to speak, is saying that they are going to try to make sure that this doesn't happen again. But while counselors helped the girl fill out the form, the Columbine principal also knew about the girl's plans and did nothing to tell the parents. Now, the mother was cleaning her daughter's room when she came across the homeless documents along with a letter describing her daughter kissing the teacher. She then uncovered thousands of calls and text messages between the two when she got their phone records. Now, investigators sent Kearney a message warning her to stop contacting the daughter and then showed the principal all the calls and texts. She said that the principal dismissed her, saying Miss Kearney simply takes an interest in helping kids navigate their sexuality. I wonder what kind of navigating was going on. I don't know. But under 18, more than 4 years age difference, that is still a sexual offense here in the state of Colorado. Anyway, the schools say that they would have reacted differently had Miss Kearney been a male teacher. But it doesn't matter because Miss Kearney quit. And it took 2 years of pressure from the mom before the teacher ultimately lost her teaching license. But where it gets even weirder is that when the teacher leaves the state of Colorado and goes to California, the student moves to California with the teacher. I'm not sure the school was looking out for everyone's best interest in this particular case. Anyway, the Jefferson County Public School District says it's conducted a thorough investigation and the principal cooperated fully. And it released a statement saying, obviously, the student did not meet the criteria to be considered homeless, and the staff involved in this isolated incident were addressed as part of the investigation as the proper channels in place were not followed. While we have taken every step to remove the former employee from Jeffco and prevent her from working in another educational setting, we recognize this is of little comfort to the family, and we deeply regret how profoundly this violation has affected their family. The school district also says it's changing its policies to ensure it doesn't happen again. Now, the mom wants more accountability for those involved, and if actions are not taken, and if people are not held accountable, it's going to happen to somebody else. I totally agree. Why, if a principal knew a teacher was engaging in an inappropriate relationship with a student, why is he still a principal? Why has he not been fired? I would dare say, going on some novel legal theories, that you could probably charge the principal with some sort of complicity in the acts of this unlawful sexual contact that was taking place. Now, it's unlikely that Jefferson County, that used to be a very, very staunch law and order type jurisdiction, will probably not prosecute anybody in this case because let's just say they've gotten a little soft on crime up there. Just throwing that out there. I don't know. Let me know in the comments what you think. Do you think somebody should actually be held accountable? Maybe somebody should go to jail for that. Maybe somebody more than just a teacher should lose their job. It's a problem we've often found out, maybe until recently, that nobody in the government ever loses their jobs. Never. Next, remember the Sydney Powell case? The one that got reversed because the judge didn't allow them to present SIR rebuttal got reversed. Well, prosecutors in Ohio are asking the Ohio Supreme Court to intervene as they fight to have Sydney Powell's murder conviction reinstated. Now, Ms. Powell is currently serving a sentence of 15 years to life for murdering her mother, Brenda Powell, back in 2020. At her murder trial in 2023, Sydney pled not guilty by reason of insanity and presented testimony from several doctors who said she suffered from multiple mental illnesses, including schizophrenia disorder. Then in December, Ohio's 9th District Court of Appeals granted Sydney's motion for a new trial, finding that the trial judge erred by not allowing her defense to present a SIR rebuttal. And in their motion arguing for Sydney's conviction to be reinstated, prosecutors said that the 9th Circuit District Court broke with more than a century of precedent and issued inaccurate guidance to trial courts, suggesting that criminal defendants have an unconditional right to present SIR rebuttal evidence whenever they assert an affirmative defense. Anyway, the prosecutors representing the state of Ohio in the appeal warned that the appellate decision could have a statewide impact, and the 9th District erroneously made a decision not only undoes the deliberative work of these jurors, but also has the potential to serve as a vehicle to entirely rewrite the order of trials throughout the state of Ohio. In sum, the prosecutors say the 9th District's decision contravenes more than a century of authority, will lead trial courts astray, and transform trials into an endless sequence of rebuttal and SIR rebuttal. Now, Powell's insanity defense, which is considered an affirmative defense, when it says, I did it, but I have a good defense, in this case, not guilty by reason of insanity. And under Ohio law, Sydney's defense argued in its appeal for a new trial that the SIR rebuttal was, in fact, a rebuttal case for the defense case in chief. No hearing date has been set for the appeal, and Sydney's defense has not yet filed a response. So remember, ladies and gentlemen, prosecution presents their case in chief. The defense, although never has to present a defense, can. And if they do, they can call witnesses. The prosecution then usually gets to present rebuttal, but it's usually very specific. Oh, somebody said the light was green. Well, we have a witness that says the light was red. Just giving a simple example. Then that's usually where it ends. But it has to be very specific. You don't get to retry your whole case all over again. And so the defense would then say, well, we have another witness that will testify that the light was the color that we thought it was. They should have been cut off at that point because, one, they had their opportunity to present their case in chief, and it would be cumulative at that particular point. And what point is it rebutting? So they go back and forth. Well, we got another witness. No, you only get one bite of it. So understand it's a weird ruling. It's involving a young, defendant, mental health issues. Maybe the Court of Appeals was trying to help somebody out. Sometimes you see that in unpublished opinions that have no precedental effect. But in this particular case, it's going to be interesting to see if the Ohio Supreme Court takes the case on cert, or they say, no, we'll let it stand. And hey, judges, don't get carried away on granting rebuttal and SIR rebuttal testimony. Next, a couple of weird guys. First, a 74-year-old man in Michigan whose wife died last year as a result of domestic abuse has been arrested after he allegedly impersonated a state trooper with the Michigan State Police in an effort to gain access to the morgue and see the 68-year-old lifeless body of his wife. Anyway, John Bromley was taken into custody earlier this month and charged with one count of aggravated domestic violence and one count of first-degree vulnerable adult abuse. Now, troopers responded to a call back in June of 2024 regarding two persons being believed to be squatting in a cabin in the Otsego County jurisdiction. Upon arrival at the address, troopers located two people later identified as the defendant and his wife. Now, troopers spoke with the duo and were able to confirm that the couple did not have permission to be on the property. The man, identified as 74-year-old John Bromley, and his wife, 68 years old at the time, were homeless and had been living in the cottage without permission. While talking with his wife, troopers noticed that she had extensive bruising and difficult breathing. An ambulance was called and she was transported to the hospital. Now, due to the severity of her conditions, Bromley's wife was transported to another hospital for specialized care. And during her stint at that facility, she spoke with troopers from Travis County and disclosed a history of domestic abuse at the hands of her husband, Mr. Bromley. Unfortunately, the victim succumbed to her injuries and died a few days after being admitted to the new hospital. Shortly thereafter, police say Bromley attempted to sneak into the morgue where his wife's body was being kept. Bromley attempted to gain access after his wife's death by impersonating a trooper, and he was not allowed access. A lengthy investigation followed, and an autopsy was performed as well. Now, the investigation report was turned over to the prosecutors, and a warrant issued for Mr. Bromley's arrest last month, and subsequently entered into the NCIC database. Anyway, he was ultimately pulled over for speeding in Michigan when he was taken into custody on those new charges of impersonating an officer. Bromley appeared at an arraignment, and his bond was set at $50,000. Since he's homeless, although he still has a car, unlikely he will post that bond. Next, this is a very weird story as well. A pastor in Arkansas has been accused of drowning cats after police found animal traps and dead animals inside his home. Now, Charles Thessing was charged with 2 counts of aggravated animal cruelty after he was accused of trapping and drowning cats. Now, Mr. Thessing had been a priest at the St. Michael Church in West Memphis, and police searched Mr. Thessing's home where they made a troubling discovery of 2 dead cats that appear to have been drowned in a tank of water found on the property. They also found animal traps presumed to have been used to capture the cats. Now, the investigation into the priest began after a tip was reported by an animal shelter. The director of that facility said the shelter takes animal cruelty cases seriously, and this case now has top priority. Needless to say, the animal rescue says that harming of a cat or any animal is unacceptable, and the Diocese of the Little Rock, Anthony B. Taylor, addressed the situation and confirmed Thessing had been suspended pending the investigation. Now, Mr. Thessing has bonded out of jail, but it's unclear what his bond will be. Don't mess with other people's cats, man. That's not cool. I'm not a big cat guy. Never had a cat in my life. Not a cat guy. Dogs, bulldogs, English bulldogs, best dogs ever. Was Miss Winnie the Bulldog, best dog ever. If you want to go there to Baketon, Colorado, you could get some dog treats with the Miss Winnie loves, and they're great. But don't mess with other people's cats. I had a case once where a guy did not like his neighbor's cat pooping on his lawn, so he trapped the cat and then drove the cat out into the plains and released the cat. My client would not have ever been charged had he not admitted to it, almost bragging about it, thinking it was funny that he stole somebody's cat. He thought it was real funny until the judge gave him jail time for that, because, cats and animals are like a member of the family. You can't go around killing people, even if it's a cat. So just keep your hands off of cats, Mr. Thessing. Next, this is why a protection order is only worth the paper that it is written on. Police in Nebraska say a 54-year-old man forced his way into his ex-girlfriend's house and shot her to death before attempting to kill himself. And guess what? It was just one day after he got out of jail for violating his bond conditions from a previous arrest where he was allegedly assaulting the girlfriend. So Casey Kint, Kindt, is accused of killing Jamie Hagan at her home in Seward, Nebraska, which is about 25 miles northwest of Lincoln, Nebraska. Now, according to the Nebraska State Patrol, Hagan's 15-year-old daughter called 911 shortly before midnight on Saturday. When the police did show up, they rushed over to the home. They saw a storm door partially open. It appeared that the interior door had been forced open. Cops put in their report, and officers yelled for anyone inside the home to come out. A man, whom officers recognized as Mr. Kint, came out with his face bleeding and a gun in a holster tucked into the front of his waistband. He was suffering from a gunshot wound, later determined to be self-inflicted. Police then searched the home and discovered Miss Hagan on the floor of the bedroom, suffering from a gunshot wounds to the forehead, arm, and chest. She had no pulse, and officers pronounced her dead on the scene. They searched another bedroom and found it locked. Hagan's 15-year-old daughter, who called 911, answered the door. She, fortunately, was unharmed. Now, paramedics took Mr. Kint to the hospital for his injuries, and the troopers are maintaining custody of him as he receives medical attention. He will be charged forthwith in this case. Now, police are familiar with Mr. Kint because apparently on December 16th, they arrested him when he allegedly threatened to assault Miss Hagen in front of another of her children. A probable cause affidavit said that he shoved Miss Hagen into shelving, doors, and walls. He is also accused of threatening to shoot her and saying, quote, "I will deck you. I will effing end you," end quote. Kint is a military veteran, apparently suffers from PTSD. Still no excuse to go beat up a woman. Anyway, police arrested him for terroristic threats, domestic violence, assault, and child abuse. And guess what? Ms. Hagen obtained a protection order against him just a few days earlier. But after he bonded out, he contacted Hagen. Immediately, the intermediary forwarded texts from Kint and said that he had something important to tell her. He allegedly discussed how he never turned her in for child neglect and SNAP benefit fraud. Kint said Hagen could make the charges go away if she wanted to. Ooh, a little witness tampering as well, right? Anyway, Hagen showed the message to the police and he was arrested. A judge increased his bond to $75,000, which, like I said, he posted and then immediately proceeded to kill his ex-girlfriend. So remember, ladies and gentlemen, that protection order is only worth the piece of paper it's written on. You need to take care of yourself. Make sure you can protect yourself and your family. Next on the docket, this day in legal history. On February 14th, 1859, Oregon was admitted to the Union as the 33rd state. Obviously, it contributed to the national discourse on slavery and states' rights, and it entered the Union as a free state amidst the tensions leading up to the Civil War. And in this date, in 1929, the St. Valentine's Day Massacre. That's right, on February 14th, 1929, 7 members of Chicago's North Side Gang were murdered at a garage on North Clark Street. The assailants, believed to be associated with Al Capone's South Side Gang, disguised themselves as police officers to execute the attack. Obviously, this event highlighted the violent gang rivalries between Prohibition-era gangs, and that intensified public demand for law enforcement to tackle organized crime. And on this day in 1936, the murder of Machine Gun Jack McGurn. So on February 14, 1936, Jack McGurn, a key member of Al Capone's Chicago outfit and a suspected organizer of the St. Valentine's Day Massacre, was murdered in a bowling alley. His death marked the decline of the Chicago outfit's dominance and highlighted the violent retribution common amongst organized crime factions during that era. Ah, the good old days. No, just kidding. Just kidding. And finally, our dumb criminal of the day. A Tennessee woman has been banned from every Walmart in the country after an epic shoplifting spree. Miss Ashley Cross cannot enter any of the grocery chain's 4,600 stores after being caught running a barcode scam. Now, Miss Cross, a known shoplifter, was caught using a barcode for a watch battery to scan multiple items for $1 at the self-checkouts. Now, the Memphis police caught Miss Cross in the process of stealing a pair of jeans, t-shirts, some boots, and 11 packs of ramen noodle from Walmart on Elvis Presley Boulevard earlier this week. The total value of everything, $137.34. She wasn't working alone, however. Another woman with her was charged with stealing $57.86 worth of goods, which included 2 bras. Now, due to her history of theft, Miss Cross has now found herself on the list that bans her from entering another Walmart again. Now, Walmart put out a statement and said, "We value our customers and associates and want them to have a pleasant shopping experience. Though rare, there are instances when someone is no longer welcome in our stores." Anyway, Miss Cross has been charged with criminal trespass and theft of merchandise of less than $1,000. She is currently in custody on a $7,500 bond. She is next scheduled to appear in court on February 19th. Crime doesn't pay, ladies and gentlemen. Remember that. Only ones who make money off of it are attorneys. And then they get it sewn in their suit. Crime doesn't pay for everybody else, ladies and gentlemen. Thanks for watching. Have a wonderful weekend. Hope you enjoyed the show. We'll see you next time. And remember, the Constitution matters.